Hi, and welcome to the Law Center videocast. I'm Larry DeMarco, your host and founder of the Law Center, the largest network of the best trial lawyers in the country, and the founder of the Law Center YouTube channel, an online resource of free educational videos for self-represented litigants in child custody court. Go to the description portion of this video for more information. Today we have a very special guest. We're here with Robert Garza. He is leading the national movement for family court reform, transforming his own personal adversity into a mission that protects children and upholds parental rights across America. Robert, thank you for being a guest on the Law Center.
Thanks for having me.
What drove you to this type of work?
Probably being 16 years in family court, spending $700,000 and going through about 43 false allegations drove me to this.
Over what time period was all that going heavy?
The whole time. In fact, I'm still in litigation. I'll be in court representing again myself pro se in about a week and a half.
So what have you specifically done in response from what happened to you, and what are you still doing relating to family court reform?
I have about 13 bills total right now that I'm trying to amend for every state. I have about 9 of them written so far, and I've already passed legislation the legislature passes legislation, drafted a bill in Texas that's now a law. It affects literally 30 million Texans within 6 months of lobbying it. And it's a great bill. It's called Time Taken, Time Back. When somebody goes through a false allegation, when they return the child, they shall return the time.
And you went on to, did you say 14, 13, 12? What's your total amount that you've drafted bills on now?
It's about 14 bills. I've drafted about 9 per state. That's about 450 bills that I've amended total so far.
You talked about Texas. How many others have you had success with?
North Dakota. When I did the Time Taken, Time Back in Texas, it went through unanimous, bipartisan the first time. The governor signed off on it. And then I had someone wanting it in North Dakota and amended the Time Taken, Time Back for there and did double the time back to really disincentivize that bad behavior, making false allegations. In doing so, it went through again very quickly and the first time. And that's when I thought, okay, I need to amend this for all the states because at that point I had everybody asking me for the bill. I just dropped everything I was doing, my regular work and everything else. And for 8 months, I've just sat here and amended bills nonstop. In doing so, I learned a lot of the different state codes, what they have, why it's not protecting them, and the legal loopholes on how the court system is able, or even bad lawyers, to weaponize the system against litigants.
Let's break down. The easiest way to go is to break down these 14 bills that you've written. Let's start at the new start at equality, where you want a 50-50 custody presumption to ensure equal parenting time and promote fairness, of course, when appropriate. How does your proposed bills differ from the efforts of National Parents Organization and the International Council for Equal Shared Parenting? Are you doing the same thing they're doing, or do you have a different approach?
I have a very different approach. In fact, I'm part of NPO. I'm on their advisory council, I believe. And so I look at this in a different way. I look at this as we're abolishing slavery. And if you think about the civil rights movement, when they abolished slavery, they didn't put that in that bill or that law that you can be president, that you can have the same voting rights as a white man or marry the opposite color. They never would have passed it. I look at this in that way is that if we're going to get 50-50 all across the board, then we need to abolish that slavery first that we're all under right now, because we're all equal. As long as you're a fit, willing, and able parent, there is no reason that you should not have 50-50. And that's what mine does. It gets you over that threshold, and then you can go back and amend all the other stuff. My bill is very pretty, and you're going to have a hard time finding a problem with it because the basic part or actually the whole bill, you have to be a fit parent, willing to do it parent, able to do it parent, live within 25 miles, and it also heightens that preponderance of evidence to clear and convincing that if the judge is going to go below that threshold, then they have to write findings and facts and conclusions of law. And that makes the courts accountable and transparent. Also, they can't give one parent less or more than the other as far as possession time, because you can just say that you have 50-50 and the judge can still write, okay, you get parent A over here gets 2 nights a week. So you stop that bad behavior from courts or not letting them go below that threshold without findings and facts. I put in there that each parent receives no less than 45% of overnights. That stops that bad behavior that they can do. Now everything is transparent and accountable.
And this works when the parents are living within 25 miles. I'm assuming that the rationale is when you're within that 25 miles, there's really no reason that both parents can't be taking this child to school or getting the child to school conveniently.
Yeah.
Let's talk about time taken, time back, which is certainly brilliant. Tell us about that, how it fights against false allegations.
Yeah, so I went through about 43 plus false allegations. They were all ruled out. They were all done by proxy. My ex never came and said, hey, Robert's hurting, harming, whatever the kids directly to the courts because she knew that that would be slander, defamation, whatever, and I could sue her. She did it by proxy. She went through third parties to do it. And so I went through about 43 of these, and every time they would give me a protective order, or they would give her a protective order restraining order by precaution by the court. And so when they're taking your parental right away, they're not supposed to be able to do that because it violates your Fifth Amendment right for due process, your 14th Amendment right for care, custody, and control on a precaution. They do it anyway. But if they do that, I thought, okay, you know what? I want my time back. So every time I asked for my time back, they just said it's water under the bridge. Let's move forward. They never gave me my time back. They got tired of me asking. They said, okay, let's save it for final trial. Well, final trial took 10 years to get to. That's unacceptable. So when I got out of court, I went to my legislator, Angela Paxton. I said, look, here's a problem in family court when they're taking your parental right away on a precaution and they're not returning that time. And every time they return my children, I have joint custody right now. They've never been able to take my custody away from my children. And so when we finally got out of court, I went to her, gave her the bill, and she was like, this is an amazing bill. And what it does is when you return the child after the investigation has been investigated and there is no finding of abuse or neglect, that you return the child, you shall return the time, the same type of time, the same exact amount of time. So if they hijack your Christmas, you get 2 in a row. A lot of people don't understand this. They think, okay, if you went through an investigation for 30 days, you only missed every first, third, and fifth weekend and every Thursday. So now when you get that time back, now you have every first, second, third, fourth, fifth weekend, first, second, third, fourth, until you get that time back. So it's the same weekends, but now the other parent's missing out on weekends and every Wednesday and Thursday. So it's a really pretty bill. It went through unanimous, bipartisan the first time. The governor signed off on it on Father's Day.
Congratulations. Well done. Tell me about the three strikes law.
So the 3 strikes, when my ex stopped making false allegations because we passed the law in Texas, she started interfering with my child custody. I was like, you got to be kidding me. Now I have to do something else to stop this. So I did what everybody else did. I called the cops. They came out, except now I know the law, right? So I sued her civilly and criminally. And so you can do both for the same situation. Civilly, you're going to file an enforcement action. Then you're going to have to pay an attorney 2 to 3 thousand, well, $3 to $5,000 now to enforce that action, and then get a date. And then opposing counsel is going to play games. It took me 6 months to get into family court to finally get in there and get this resolved. On the criminal side, I had the police take a report. They gave it to a detective in the youth division. They found probable cause. They gave it to the DA, and then the DA gave it to the grand jury to indict or not indict. That's when I found the legal loopholes. And so they didn't indict because in Texas, because of the wording, only the non-custodial can be found held into this law. And so I took that information and I talked to the DA, and not only the DA in my district, I talked to DAs all over the country and found out that this is called grand jury bait, that the law is there, but nobody really gets in trouble for it. And if they do get to the grand jury, then it's just a procedure that they're just going to dismiss it. So I asked if we could do a three strikes law and what did they think about it. Every one of them loved it. That because the three strikes law that I came up with, I'm amending that state jail felony, and it's pretty much a state jail felony in every state to withhold a child on someone else's parenting time. And so what the three strikes law does, it amends it to be two misdemeanors before the felony. Now, when the policeman comes out, he can give a ticket the first time, the second time, and the third time it becomes a felony, what it is right now. This is perfect for protective parents because if you're a protective parent and it's really abuse is really happening, then it gives you enough time to go get a protective order, restraining order. But if you're not and you're playing games, then you're going to get two $500 fines and then you're going to be arrested. And in doing so, it with all these detectives and these district attorneys' offices, they loved it because it shows a pattern of bad behavior. And that's what's so good about this bill. The other thing is when you get this $500 fine, if there really is abuse, you can just go to a criminal court, not a family court, and get it dismissed. You're going to be the one in front of the judge, and the judge is going to say, hey, did you have a reason to do this? And if you can't show him clear and convincing evidence, not just saying it on a preponderance, this is criminal court. You're going to have to show where you took that child to CPS or to get help and there was really something there, not just, oh, I let him go play video games the rest of the day. That $500 sticks. So do it again, you're gonna be arrested or something. So now there's consequences for that, and it also gives the state money for going out there and instead of wasting state resources or county resources, we have over 1,000 interference with child custody calls in San Antonio, Texas a month. They have to hire extra police. That's wasting our taxpayer dollars to go out there to tell them to go to family court, and it's doing nothing right now. After this law passes, 1,000 interference with child custody calls, that's $5 million to basically that city in fines if people are still playing games. Now, I hope nobody gets a fine or goes to jail. I hope this stops the bad behavior before it starts.
It sounds effective, and I'm sure it is. Tell me about justice delayed is justice denied.
On the justice delayed, justice denied, when I did file enforcement in a family court, it took me 6 months to get there, and then the judge didn't rule on it. And I was like, why isn't the judge ruling? This is crazy. And 20, 60, 30, 90 days went by, and I'm like, the judge still hasn't ruled. So I looked into the law and found out that pretty much in every state except for about three, the judges don't have a hard stop on how many days they can take to rule on a case. In fact, they can just leave you in legal limbo if they want. So that's not justice. In fact, that's justice delayed is justice denied. And my judge took 6 months to make a ruling on an enforcement that took 6 months to get in there. That's over a year to get justice. That's way too long. If this was a thing where kids were involved and they were withholding them or something, they had enough time to brainwash, alienate, emotionally abuse, and everything else. So what the justice delayed, justice denied does is it cleans up the court system, it adds more transparency and accountability, and it doesn't take discretion away from a judge because it makes them rule within 10 days. But if they need more days, it's in there that if there's someone that are using drugs, that they're waiting on a test, that after the hearing, it gives them 7 days to rule on after they receive those tests or whatever. But if they need more time, it also says that they can have 10 days more every time, but every 10 days they have to write why they need more days. So it adds accountability to the court. So they may just go ahead and rule because if not, they're going to be writing something anyway. So I'll ask you this. What did you have for lunch last Thursday?
Don't remember.
Exactly. And that's because you have 3 meals a day. A judge sees 10 to 15 cases a day, the same types of cases. They're not going to remember. They're not a computer. They're human. We make mistakes. And when you're spending tens of thousands of dollars to get in there, the judge needs to rule right away, if not within 2 or 3 days. I have judges and lawyers ready to testify that they run their courtrooms like this, judges do, and lawyers see this all the time. Where the bad apples are is when they start taking more than 10 days because, like you said, you don't even remember. If they go back and just read, let's just say you're a pro se, and they read opposing counsel's version of their recollection or their pleadings, and then they read yours, what was the point of having the hearing or the trial anyway? She might have just done it on submission if they're going to do that and make a ruling anyway. So this will clean up the court systems very fast, and it adds accountability and transparency.
Thank you. For cameras in the courtroom, your law number 5, how do you ensure the privacy of children? Who has access to the footage and under what circumstances?
Yeah. So in my bill, the only people that get access to that footage is the litigants, the counsel, and if you're doing an appeal. And so the reason for the audio and video of the courtroom is that if you're pro se, sometimes you get in there and you get amnesia. I don't know if you've ever had that court amnesia, but you can't remember things. And if the judge is making a ruling and you're pro se, and let's just say you're indigent, you have to pay for a transcript. They're not just going to give it to you. So at least when you're making your proposed order on what the judge ruled and you're submitting, dueling proposed orders because, opposing counsel is going to write stuff that the judge didn't say in there, at least you can rewind the tape and show the judge, hey, mine's 100%, here you go. And at least you have something to write it by. That's what that purpose is for. It's to not delay justice also. The other thing it does is that when you hear the judge say, okay, we're on the record or off the record, when they go off that record, there is nothing being recorded. Same thing, if they tell you to sit down and it's on the record, it's different if they stand up, shake their finger at you and tell you to sit down. On the record, it sounds just the same, sit down or the other way. So there is no inflection, there's no facial expressions, but on the video there is. And that's why a lot of these judges are getting away with a lot of stuff that they're doing, and it's not on the record. This will keep a record of the whole time. This is on the record and off the record recordings and any other things that are being in the courtroom.
So for only attorneys and the litigants have access to this.
Correct. And appellate court. Correct.
Temporary orders, making them appealable in all states. Now, appeals can take years, and you're not supposed to have litigation during an appeal. How do you get around that when there's multiple issues going on and you'll have to delay something else because of an interlocutory order?
Right. So the problem that most people are having right now is a lot of judges, when you go in there and there's conflict, they have friends that are the guardian ad litems that they appoint to your case. They have friends that are the psych eval, the home study, the parent facilitator. They're just handing out cookies to everybody, all their friends, and they're appointing them for all these cases that they have. That's a massive problem. It cost me $160,000 for my guardian ad litem, and we both had to pay half on top of our own attorneys. They assigned me home studies, psych evals. The psych eval person went to school with opposing counsel and was his dorm roommate. That's how incestuous this is. And it just doesn't, it's not just here, it's everywhere. So appealable orders, if you're, and let's just say you're even indigent, if you go in there and tell the judge, look, I'm here representing myself, I can't even pay for an attorney, and they're signing you guardian ad litems and home studies and psych evals and all these other things, and you can't pay for them, then there's nothing you can do and you're stuck in legal limbo. You can't even appeal it because of what the rules are right now. But after this goes through, now you can appeal those if they assign all those, because you can show on the record that you told the judge you were indigent and still assigned all these things. And it's not just for that, it's for all kinds of things, because opposing counsel can be in there making up false allegations, and then you're put under all these extra things. And it just makes it where it's cleaner and more efficient if you can appeal a temporary order.
What parental alienating behaviors are specifically enumerated in your bills so that judges know when to apply these reimbursement of fees? Because parents often argue they're not alienating, they're withholding based upon protecting the child.
Yeah. That's where I left it to the judge's discretion. Remember, some of these bills are not to take the discretion away from judges, but it's there in case somebody is playing these games. Does that make sense?
Yes, what I understand is you are using general language and you're doing this for when judges see there's some type of deliberate behavior to harm the relationship between the opposite parent and child.
Correct.
Thank you.
They have their discretion.
Number 9, the litigation access and economy bill. How do you balance the requirement for one party to be present for cross-examination and perhaps not have something in writing off of camera versus that economic burden if someone can't get out of work or can't make it into a hearing? Do you specify the types of hearing, or how specific do you get here?
Yeah, so it's very specific and it gives the judge the discretion still to make the litigant come to court, but it also gives the litigant access to not have to come to court if they don't want, because of if they're trying to work and everyone's a paycheck away from poverty pretty much, then they don't need to be taking that day off or having to hire someone for childcare or anything else. They can still be at home and still do what they need to do. The reason this bill was born was because a friend of mine's an attorney. We were talking. He had to charge his litigant $1,200 for a 2-minute hearing. I was like, that's crazy. He's like, yeah. He's like, we could have just zoomed in, but the judge is stickler about that. And I was like, well, why don't we come up with something that all hearings are by Zoom unless the judge says, hey, I need you here. That shifts the burden. Now it's open courts, and it also allows the public to be able to kind of come in and see what's going on too.
Thank you. For number 10, indigent litigants, the mandatory transcript fee. I know Pennsylvania has something called informa pauperis if someone has a hardship, and I imagine some, if not all, most, if not all states have something for people who can't afford certain costs. What did you see that was inefficient and that you needed to change? How do you complement or replace what's already there with this one?
Yeah, so most of these were from people that had problems trying to get this. And so on the transcript, one of them cost me, I think, $1,500 just for one transcript after I already had paid for everything. And then I had to wait weeks because the transcriber was behind and I needed the stuff immediately. So a lot of this stuff just needs to be opened up. And I think what would stop that too is being able to record and get that recording because of the cameras in the courtroom. So all of these work together somehow. And if one doesn't go through, the other one will kind of fix it. And so all of these just basically help each other one way or another. They're all intertwined.
Let's go to number 11, role and limitations of guardians ad litem.
I'm taking that quasi judicial immunity away and making it to where they're held to the same standard and can be sued as a professional can.
Gotcha.
And that will make more accountability, more transparency, and better rulings.
So in other words, you want a professional licensure, whether it's legal or social work or psychologist. You want a licensure and an ordinary standard of care from a qualified family court professional.
That would be the best way to do it. But again, a lot of these guardian ad litems are the friends of the judges. And so if you put in a bill that takes away that they have to have these licenses, all of a sudden they're fighting for their friends. Leave it and just make them accountable, just like any professional would be, that they can be sued and they do not have quasi judicial immunity.
So it's about eliminating immunity is what Bill 11 is for.
Yeah.
Thank you. Family Court Fairness Act.
So that bill's really neat. So there's pending charges and there's a conviction when you're in criminal court. A lot of attorneys are weaponizing and bringing in BS criminal stuff and trying to get someone in trouble for whatever it is to bring it into family court to get them their parenting time clip or to make them submit to something else. So in that bill, basically you cannot bring anything into family court unless there's a conviction or someone that has, what do you call it, is deferred, or, that's a conviction too. They've pleaded out, or if there's a conviction, only then can you bring it into family court. If not, then you have to have a separate hearing with family court. So you're not saying that you are going to keep it out, but you can't just bring all kinds of crazy stuff in. And so you have to have a separate hearing on that matter. And then in that hearing, the judge says, okay, you can bring it in or leave it out, and then have whatever hearing you're going to have. But you can't just weaponize an allegation because of whatever. This keeps that out.
Gotcha. Due Process Restoration Act. I know in Pennsylvania we have something called the Clean Slate Bill, where summary offenses or misdemeanors are expunged. How specific do you get relating to the automatic expunction of dissolved, dismissed, or expired protective orders? You don't want people weaponizing something that happened over 3 years ago. Is that the purpose of this?
Or anything at all. So if you have a protective order, restraining order, nobody violated it, and they did it on precaution. Let's just say mine, 43 times. You got to be kidding me. So if someone looks into my background, they're going to be like, wait, why were all these protective orders, restraining orders from the court? So what this does, whenever that judge dissolves that protective order, restraining order, they automatically sign one more piece of paper that takes it off your record.
So are you talking about expunging the allegations and the ones that you won so you can eliminate any record of a false accusation?
Correct.
Understood. Well done.
Yeah, why nobody's ever thought of these, I have no idea.
Well, I certainly understand there's a lack of empathy or sympathy for people who have to fight false allegations,
Yeah,
and
sorry, 1 second.
you're really closing a loophole that we appreciate. Robert, number 14, the Family Rights and Due Process Act. What is it, and what is it targeted to fix?
Yes, so that one's an amazing bill. That one takes, so right now, the legal standard to do anything, and actually it's in all 50 states, is preponderance of evidence. It's the lowest standard. It's 50% plus a feather. So when they look at evidence, they say, is it more true or less true? And that's the problem that we're having. And that's why people go in there and make false allegations. They perjure themselves and whatever else. But the judge still is like, it sounds more true or less true. And they go off of that. That is such a bad standard when you're dealing with families and children. Now, to take away a parental right in any family court in all 50 states, you have to have clear and convincing evidence right now. So, why would the standard be anything less in family court when you're dealing with children and family? So, what this does is it heightens that standard to be clear and convincing for anything in family court. And right now, we're having such a big problem with people perjuring themselves. But if they do right after this goes through, the judge is going to say, prove it. Show me the evidence. They're not going to weigh it as, it sounds more true or less true. Same thing with a false allegation. The judge is going to say, show me the evidence. Because now it's not like, that sounds more believable than less believable. And this heightens that standard on all of those.
Generally speaking, which bills have been passed across the states and which are legislatures interested in pursuing?
Yes. So we've had time taken double the time back in North Dakota. We've had several bills in Texas also pass with the three strikes civil version and several others to do with the judiciary where they hold judges accountable.
Generally speaking, which bills have been passed across the states and which are legislatures interested in pursuing?
Yes. We've had time taken double the time back in North Dakota. We've had several bills in Texas also pass with the three strikes civil version and several others to do with the judiciary where they hold judges accountable. But right now, the biggest part is in the last 8 months, the legislators have been closed to new bills. And so I've written these in the last 8 months. So now these are about to go through all 50 states. About 9 of these bills will be hitting all of your states at once.
Great. You've given us a lot of information. If we want to research some of these bills and learn more about you, Robert, how can we find out more information online?
Yeah, just go to robertgarza.us. You can sign up to be an advocate. You can help pass these bills in your state. You'll be notified when there's hearings on these bills, and you can testify for them. The more, the better. The other way is you can go to my Facebook page, Robert Garza, and you can watch all of my reels and you can see the support behind it. We have senators behind these bills testifying for them. We have House reps, we have Democrat, Republican. It doesn't matter. This is a bipartisan issue. You're dealing with children and families. It's everyone's issue. This is the biggest civil rights movement since the civil rights. And we can't have a strong nation without having strong families. And this will ensure that.
And do you offer any coaching or services to help pass a bill, whether it's on a volunteer basis or even one-on-one paid coaching?
So to do any kind of the legislation, it is all free. I charge nothing for it. I've written all these bills for everybody, and hopefully this will clean up the court system. We do donations. If you want to make a donation, that helps immensely. Right now, we don't really have a lot of funds, and we're about to travel all over the US to get these bills passed and have to testify. So hotels, transportation, all that good stuff.
Thank you for your advocacy. Robert, that's all we have time for today. Let's leave it there. But I want to thank you for being a guest on the Law Center videocast.
Thanks for having me.
We've been here with Robert Garza, and I am your host, Larry DeMarco. Thanks for watching. Don't forget to subscribe, share, like, and comment. Also, click the notification bell to be alerted of new videos. This has been brought to you by the Law Center, the largest network of the best trial lawyers in the United States. Go to the description portion of this video where you can learn more about Robert Garza and the Law Center Attorney Network and the Family Court Custody Boot Camp. Signing off. Tune in next time. Bye for now.